The top 5 things not to do if you've been served. Number 1, don't ignore a summons. Once you receive a summons and complaint, a foreclosure action has already been filed in the court system. Pursuant to Florida law, you have 20 days to file a written response with the court. If you do not file a response, the lender will be able to file a motion for default and obtain a default judgment against you. A default means that you lose the right to assert defenses in the case. If you do not respond or have an attorney respond for you, it makes it very easy for the bank to obtain a sale date on your property. Number 2, don't file something without knowing these 2 rules. Rule 1. Before you file your response, you need to be aware that everything you file will become a permanent record in the case. Rule 2. You also need to know that some defenses that may be available to you are waived if you do not raise them in your initial response. Therefore, it is imperative that you thoroughly examine your mortgage documents as well as the court documents for any defenses, defects, or standing issues. Plus, are careful not to file anything that can hurt your case. Number 3, don't expect the lender to put foreclosure on hold while you try to modify your loan. Countless homeowners believe that the lender will halt foreclosure proceedings while they are going through the modification process. This couldn't be further from the truth. Lenders most certainly continue with foreclosure proceedings while you apply for various alternatives, including loan modifications, short sales, and deed in lieu of foreclosures. Number 4, don't miss your court-mandated mediation. In Florida, the Supreme Court has mandated mediation for all residential homestead property in foreclosure. Mediation is a great opportunity for you to sit down with the bank representative and their attorney and try to work out a resolution to your mortgage issue. The bank representative must have settlement authority, which means they must have the authority to offer you a modification, reinstatement, or other resolution on the spot. The mediation centers that have been designated to handle these mediations will contact you shortly after you are served with the foreclosure documents. If you fail to take advantage of their services, the lender will file an affidavit of noncompliance with the mediation program, and you will miss a great opportunity to resolve your case. Number 5, don't represent yourself in court. You wouldn't consider performing surgery on yourself or give yourself a root canal, so why would you go into a hearing, stand in front of a judge, and try to defeat the bank's attorney? The truth is, the legal process is complex, and without proper training, you are ill-equipped to defend yourself. Countless heartbroken homeowners come to attorneys only after trying to defend themselves and end up with a judgment and a sale date on their property. For most people, a home is the single largest purchase they will ever make. It's just not worth it to leave a foreclosure to chance. So before you walk into the courtroom, consult with an experienced foreclosure defense attorney and make sure you are properly represented.